What is the history of environmental protection in armed conflict? Imagine a war where the environment itself becomes a battlefield. That idea might seem new, but protecting nature during war has been part of international law for decades. In the past, laws of were mainly focused on saving civilians, protecting soldiers, and safeguarding cultural treasures. The environment was rarely mentioned explicitly. It was only about 50 years ago that nations started to recognize that ecosystems also need protection during conflicts. This shift happened because wars can cause serious damage to forests, rivers, and wildlife. Such damage can last 4 years and harm human health and food supplies. Recognizing this, international agreements began to include rules to limit environmental harm. One of the first steps was the adoption of the additional protocols to the Geneva Conventions in the late 1970s. These protocols set clear limits on causing widespread or long-lasting damage to nature. They also banned methods of warfare designed to destroy the environment intentionally. The Gulf War in 1991 was a turning point. During this conflict, Iraq set Kuwaiti oil wells on fire and spilled oil into the Persian Gulf. These acts caused massive ecological damage and showed how war could devastate ecosystems. This event sparked debates about whether existing laws were enough to protect the environment. Since then, international law has continued to evolve. Today, principles like the prohibition of unnecessary destruction and the idea that environmental harm should be proportional to military gains are key. These rules aim to balance military needs with protecting nature. Overall, the history of environmental protection in armed conflict is about moving from vague ideas to clear legal standards. It reflects a growing understanding that safeguarding ecosystems is essential for the well-being of civilians and the planet. This ongoing development helps ensure that, even in war, nature is not left defenseless.